Hello everyone. Hope you are doing well and high in your spirits. Today we are going to revise the part of your syllabus that deals with union and territory precisely from Articles 1 to 4, including name and type of polity, the rationale behind it, the Article 2 that is how it is different from Article 3. In Article 3, we will elaborately discuss the procedure adopted for reorganization of states and what is Article 4, what Article 4 says, and again we will discuss the difference between cession of territory and settlement of border dispute, and does any constitutional amendment is required for any one of these two or not. So we will see all of these in this class. If you have done all these things and if you are confident enough, you can entirely skip the video. But if you have any doubt, you can watch this class. छोटी सी ही discussion होगी ये from Article 1 to 4, and we will cover thoroughly, and I can guarantee you that you are going to get the best ever discussion over this topic. And I'll try to keep the discussion bilingual so that both English medium and Hindi medium students can uh, join the class and reap the benefit of this discussion. So let's shift over the content of our class. Okay, so let's shift on the content part of the Union and its territory. See, for discussing Union and its territory, it is very important to understand what has been written in the Constitution. So I have borrowed Articles 1 to 4 from the Constitution itself. Precisely Article 1 to 4 we have copied here, and we are going to discuss based on those articles. And these are very important for your exam, for prelims as well as mains as well as. So do understand them carefully. So if you read Article 1 of the Constitution, it says that India, that is Bharat, shall be union of states. What is Article 1? It deals with name and territory of the union. And Article 1 clause 1 says that India, that is Bharat, shall be union of state. हम बाकी clauses को बाद में पढ़ेंगे. So if you see, there is two components in Article 1 that we need to focus upon, and that is firstly the first part, India, that is Bharat part, and secondly, union of state parts. Precisely what I want to convey, Article 1 deals with two parts, that is name of the union, and secondly, type of polity. Whether we are union of state or federation of state, it has been made clear in Article 1. So when it comes to name of the country, name of the union, the article says the name would be India, that is Bharat. What is the name of our union? India, that is Bharat. Why such name has been adopted? So when you refer to the Constituent Assembly debate, you see that there was no unanimity when it comes to name of the country. Some traditional members emphasized upon the traditional name of the country, that is Bharat, while other advocates, other members who were technically forward, they advocated for the modern name of the country, that is India. So basically we adopted mix of both, mix of. So the name of our country itself reflects the mix of tradition and modernity. So name of tradition and modernity, and that too is reflected in the verboise of your fundamental duties. So basically, come here. Name of our country, that is India, that is Bharat, is a reflection of mix of tradition and modernity. Secondly, if you read Article 1 in its second part, it reflects that India, that is Bharat, that is our country, is a union of a state. So this article clearly specified the type of polity, that is we are union of state rather than federation of states. Though our constitution is federal in character, but our polity is of Indian union. So while explaining this provision, Dr. B.R. Ambedkar explained that why we have preferred union of state over federation of state, because our constitution have federal character, right? But we are preferring union of states over federation of state. Why? Then Dr. Ambedkar said that this preference has been made for two reasons. Firstly, because Indian Federation is not a result of an agreement between the states. Our federation is not result of agreement. States के बीच में कोई agreement नहीं हुआ है और उसके बाद कोई federation नहीं बना है. our federation is not a result of agreement between the states. And secondly, in this federation, states have no right to secede. So these are the two grounds for preferring a union of states over federation of states, and Dr. Ambedkar quoted that our federation is union because of its indestructible nature. And from where indestructible nature comes? From the second part, that is states have no right to secede. So coming back again to the Article 1, if you read Article 1, Clause 3, Subclause A, it explains the territory of India shall comprise territory of states, union territories, and the territories may be acquired. Let me express it through bullet points. So basically, Article 1, Clause 3, Subclause A says that territory of India includes three types of territory. What are they? Territory of states, union territory, and territory acquired at any time. And basically, if you read Article 1, it gives the constitutional basis for the expansion of Indian Union. Do remember this. That is, at any time in future, the Indian Union can acquire certain foreign territory and integrate and establish it as a part of India. So basically, Article 1 gives the constitutional basis for the expansion of Indian Union. So, territory of India includes states, UT, and acquired territory. Secondly, if you read Article 1, Clause 2, it says that the states and territories thereof shall be specified in the fourth schedule. So, जो states and UTs के names हैं और उनके एक टेरिटोरियल एक्सटेंस है, किस शेड्यूल में स्पेसिफाइड है? फर्स्ट शेड्यूल में स्पेसिफाइड है, ये आपको याद रखना है. Again, we have two terms, territory of India and union of India. So let's compare the constitutional expansion of territory of India and union of India. So when it comes to territory of India, it is said that territory of India is a wider expression as compared to union of India. And why? Because if you see union of India, it includes only states. If you see Union of India, it includes only states, but when it comes to territory of India, it not only includes states but also includes UTs and acquired territories that can be which will be acquired anytime in future. So remember that the states are members of federation. States are members of federation and they are also called as constituent on federation, and there is a distribution of power. The states share distribution of power with center, not UTs. Do remember this. Only states are units of federation, not UTs. So states are units of federation and they share a distribution of power with center. But UTs and acquired territories, they are directly administered by the यूनियन गवर्नमेंट. सो जो आप कमेंट्स में लिखते हैं कि यूनियन टेरिटरीज का कंसोलिडेटेड फंड होगा कि नहीं, फेडरेशन में उनका क्या रोल है, तो बिकॉज यू आर लैकिंग इन योर बेसिक्स दैट ओनली स्टेट्स आर यूनिट्स ऑफ फेडरेशन, नॉट यूटीज आर यूनिट्स ऑफ फेडरेशन. सो जहाँ भी डिस्ट्रीब्यूशन ऑफ पावर होगा वो सिर्फ और सिर्फ यूनियन एंड स्टेट्स एंड दो स्टेट्स के बीच में ही होगा. यूटीज आर डायरेक्टली administer and under complete control of the central government. ये आप याद रखेंगे कि UTs complete control में आती है central government. So there is no question of distribution of power. So this is the essence. This is the whole thing related to Article 1 of the Constitution. What it provides us is name of the country and its type of polity. Why we adopted mix that is India, that is Bharat, because some members were pressing for traditional name while other members were pressing for modern name. So we adopted kind of mix of that. Again, it also it also explained that first schedule includes the name and extent of states and UTs, and Article 1 also explain what constitutes territory of India. याद रखेंगे टेरिटरी ऑफ इंडिया में क्या क्या आता है, स्टेट्स आते हैं, यूटीज आते हैं, एक्वायर्ड टेरिटरीज आते हैं. एंड टेरिटरी ऑफ इंडिया इज अ वाइडर एक्सप्रेशन दैन यूनियन ऑफ इंडिया, बिकॉज इन यूनियन we only have states, and only states constitute federation, and only there is a distribution of power with states only, not with UTs. But when it come to territory of India, it is a wider expression because it not only consists of states, it includes UTs and acquired territories, and they are directly administered and in complete control of the central government. So do remember this much essence when you go in the exam hall for related for Article 1 of the Constitution. Now come to Article 2 of the Constitution. So basically Article 2 of the Constitution deals with admission or establishment of new states. These two words are very important for us, and I would like to emphasize admission or establishment of new states. And these states, these are those states which are not part of Indian Union. Do remember this, not part of Indian Union. So basically Article 2 says that Parliament who can admit or establish new state. So the first question is, who can admit or establish new state in the Union? So the answer is Parliament. Indian Parliament, by making law, can admit. These two words are very important. Can admit or establish new state in the Indian Union. And simultaneously, Parliament can express the terms and conditions also on which the new states are admitted or established. So when it comes to admission and establishment of new states, do remember the term admission means admission of already existing states. But when it comes to establishment of state means establishment of non-existing states. So Parliament by law can establish or admit new states into the Indian Union on such terms and conditions as the Parliament thinks fit. And do remember that the term state in the Article 2 has been expressly used for those states which are not part of Union of India. Do remember this. So these are, for example, if you see example, the integration of Sikkim into Indian Union is a classic example of Article 2. By 35th Amendment that was enacted in 1974, Sikkim has been given a associate state. Status of associate state was awarded to Sikkim, and subsequently in 1975, through another amendment, that is 36th Amendment, the Sikkim was granted complete statehood, and it was given 22nd. It was made 22nd state in Indian Union. So basically, the classic example of integration of Sikkim into Indian Union is an example of Article 2 of the Constitution. Do remember and take this essence with you. Remember that Article 2 deals with admission or establishment of those states which are not part of Indian Union, whereas when it comes to Article 3, it talks about changes or formation in the existing state. That is, Article 2 talks about acquisition of territories which are not part of India, and Article 3 talks about internal readjustment. So Article talk about acquisition of territories. We have just read Article 1, and it says that territory of India include acquired territory. So Article 2 basically talks about acquisition of territory, acquired territory. And by virtue of Article 1 and 2, the Constitution has given sanction for the expansion of territory of India. Do remember this. Now come to excuse me. Now come to Article 3 of the Constitution. So Article 3, do remember that Article 3, everything in the Article 3 deals with internal readjustment. This word is very important. Internal readjustment of within Indian Union. So it talks about घर के अंदर के चेंजेस की बात कर रहे हैं हम. घर के बाहर से जो कुछ लाते थे वो आर्टिकल 2 में हम डील करते थे, और घर के अंदर ही कुछ बदलाव करनी है, एक दीवार को बदल के एक दो दीवारों को मर्ज कर देना है या फिर एक दीवार को तोड़ देनी है, ये सारी बातें घर के अंदर की बातें हम आर्टिकल 3 में करते हैं. एंड दैट इज व्हाई इट इज नोन एज internal readjustment. The title of Article 3 talks about formation. The first word is formation of new states and alteration of areas, boundaries, names and of existing state. So Article 3 says, just a minute. Article 3 says that Parliament by law, एक minute, yes. Article 3 says कि Parliament लॉ इनेक्ट करके नए स्टेट का इंडियन यूनियन के एग्जिस्टिंग स्टेट्स में से किसी टेरिटरी को, दो एग्जिस्टिंग स्टेट्स हैं, इनके सर्टेन टेरिटरी को सेपरेट करके एक न्यू टेरिटरी, न्यू स्टेट बना सकती है, या फिर दो स्टेट्स को मर्ज करके एक न्यू, दो स्टेट्स हैं इनको कंप्लीटली मर्ज करके एक न्यू स्टेट बना सकती है, या फिर एक स्टेट से एक सर्टेन पार्ट को अलग करके एक न्यू स्टेट बना सकती है. ये आप याद रखेंगे. एंड दैट इज डेल्ट इन आर्टिकल 3A of the Constitution, that Parliament by law form a new state by separation of territory from any state, or by uniting two or more states or parts of it, or by uniting any territory to part of states. आप दो स्टेट्स को सेपरेट कर सकते हैं लॉ बनाने के लिए, नई स्टेट बनाने के लिए, या फिर एक स्टेट से एक सर्टेन टेरिटरी को निकाल करके एक नया बना सकते हैं, या फिर दो स्टेट्स के डिफरेंट टेरिटरीज को जस्ट अ मिनट भी यूनाइट करके एक नई टेरिटरी बना सकते हैं. सो बेसिकली आर्टिकल 3 डील्स विथ स्टेट्स विच आर पार्ट ऑफ यूनियन ऑफ इंडिया, and it is a basically internal organization. Article 3A talks about formation of new states. 3B talks about increasing the area of existing state. 3C talks about diminishing the area of existing state. 3D talks about altering the boundary, change in boundary of the existing state. And 3E talks about altering, yani changing the name of existing state. So by virtue of Article 3, Parliament is empowered to do all these things. Do remember this, and this all comes under internal readjustment. It can be asked कि इंटरनल रीएडजस्टमेंट में क्या क्या आता है. तो एग्जिस्टिंग स्टेट्स में चेंजेस करके, मर्जर करके, सेपरेशन करके नए स्टेट का फॉर्मेशन इंटरनल रीएडजस्टमेंट में आता है. किसी एग्जिस्टिंग स्टेट के एरिया को इंक्रीज या डिक्रीज करना इंटरनल रीएडजस्टमेंट में आता है. एग्जिस्टिंग स्टेट के बाउंड्री को अल्टर करना, इट कैन बी इंक्रीज और डिक्रीज. एग्जिस्टिंग स्टेट के बाउंड्री नेम को अल्टर करना, दैट इज चेंज करना, इंटरनल रीएडजस्टमेंट में आता है. सो what it says that parliament by law, यानी इंटरनल रीएडजस्टमेंट करने के लिए क्या करना होगा, पार्लियामेंट को लॉ बनाना होगा. एंड डू रिमेंबर, फॉर दिस पर्पज अ बिल हैज टू बी इंट्रोड्यूस्ड इन द हाउस ऑफ द इन एनी हाउस ऑफ द पार्लियामेंट. याद रखेंगे कि बिल किसी भी हाउस में इंट्रोड्यूस हो सकता है, बट देयर इज अ कंडीशन, एंड द कंडीशन इज दैट द बिल कैन only be introduced on the prior recommendation of the president, prior sanction of the president. प्रेसिडेंट के प्रायर सैंक्शन लेने पे ही बिल इंट्रोड्यूस हो सकता है, एंड इट कैन बी इंट्रोड्यूस इन ईदर हाउस ऑफ पार्लियामेंट. बट देयर इज अ कैविएट, देयर इज अ ड्यूटी इम्पोज्ड ऑन द प्रेसिडेंट, एंड इट सेज दैट President prior giving sanction for the introduction of such bill in for the purpose under Article 3 has to refer to the concerned state legislature. जिस स्टेट का नक्शा बदले जाने वाला है, लेमन के शब्दों में कहूं, जिस स्टेट का नक्शा बदला जाने वाला है, उस स्टेट के लेजिस्लेचर से प्रेसिडेंट विल आस्क ओपिनियन विद इन अ स्पेसिफाइड टाइम, ये वर्ड इंपॉर्टेंट है, विद इन अ स्पेसिफाइड टाइम, स्टेट लेजिस्लेचर हैव स्पेसिफाइड टाइम, स्टेट लेजिस्लेचर को अपना ओपिनियन भेजना पड़ेगा प्रेसिडेंट को, एंड आफ्टर गेटिंग दिस opinion of the state legislature only president can give prior sanction to the bill. Do remember that though state legislature has to give its opinion in a given time, but this opinion of the state legislature is not binding on the president. It is entirely discretion on the president that if president wishes, president can go with the concerns of the state legislature, or if president wishes, president can entirely dismiss the concern of the state legislature. याद रखेंगे, state legislature जो भी opinion दे रही है, that is not binding on the president. And once president has given sanction to the bill can be introduced in either house of parliament. And do remember that that any bill for the purpose of article 3 requires only simple majority, and that too with ordinary legislation. And any changes made in the constitution, whether in article 2 or 3, do remember that it does not come under article 368 of the constitution. याद रखेंगे आप, changes made under article 2 and 3 of the constitution are not considered as amendment on article 368, because these are the changes are brought about with ordinary legislation that required simple majority. And that is why it is said that क्योंकि ये दिस सीड आप एक स्टेट के नक्शे को बदल दे रहे हैं, एक ऑर्डिनरी जिस तरह से कानून पास होता है उस तरह से आप एक स्टेट के नक्शे को बदल सकते हैं. दैट इज व्हाई इट इज सेड दैट पार्लियामेंट जो है अपने पार्लियामेंट इंडिया के पॉलिटिकल मैप को इंटायरली रीड्रॉ कर सकता है बेस्ड अपॉन इट्स विल, क्योंकि एक फॉर्मेलिटी है. डू रिमेम्बर दैट प्रेसिडेंट का स्टेट लेजिस्लेचर को रिफर करना एक फॉर्मेलिटी है. It is mere formalistic. This reference has formalistic value only. It is not binding. It is just a procedure given in the constitution that needs to be followed. क्योंकि states अगर disagree भी होते हैं या फिर dissent express करते हैं, still it's up to president to give assent to the bill, and president works on the, and again this entire exercise of the president is based on the aid and advice of council of ministers headed by prime ministers. So this is not a discretion of the president. So do remember that the parliament can change the political map of India based on its will, because इसमें states का कोई role ही नहीं है. And that is why it is said that the territorial integrity of the states are not guaranteed under Indian constitution. And that is why it is also said that कि Indian Union is an indestructible union of destructible states. हमने यहाँ पे देखा स्टेट्स के डिस्ट्रक्टिबल नेचर को आर्टिकल 3 क्लियरली दिखाता है. एंड हमने इनडिस्ट्रक्टिबल यूनियन देखा था व्हेन व्हाइल वी सॉ आर्टिकल 1 ऑफ द कॉन्स्टिट्यूशन दैट स्टेट्स हैव नो राइट टू secede from the union. Dr. B.R. Ambedkar, while explaining the preference of the term Union of India over Federation of India, explained that states do not have any right to secede. States union से बाहर जा ही नहीं सकते. So do remember this. Besides internal readjustment of related to states, Parliament also have power for the internal readjustment when it comes to UTs. And do remember, जैसे यूटी दो या एक स्टेट या जैसे दो या दो से अधिक स्टेट्स के मर्जर का प्रोविजन है, नेम्स बाउंड्री चेंज करने का प्रोविजन है, इन सेम वे पार्लियामेंट कैन यूनाइट एनी एग्जिस्टिंग पार्ट ऑफ अ यूटी टू अनदर पार्ट ऑफ यूटी एंड क्रिएट अनदर यूटी. दैट इज यूटीज का भी इंटरनल ऑर्गेनाइजेशन हो सकता है. एंड याद रखेंगे कि दो स्टेट्स के इंटरनल ऑर्गेनाइजेशन के लिए कंसर्न स्टेट लेजिस्लेचर को रिफर करना तो जरूरी था, बट फॉर इंटरनल ऑर्गेनाइजेशन UTs, there is no need of referring to their state legislature. Parliament and president can take suo motu notice in this regard UTs, because UTs do not constitute the UT do not come under federation. They are directly administered and are under complete control of the central government. So ये आप याद रखेंगे. एंड डू रिमेम्बर, जैसा आर्टिकल 3 के लिए बताया, आर्टिकल 2 के लिए भी जो भी नए स्टेट्स का एडमिशन या फिर इस्टेब्लिशमेंट होता है, दिस इंटायर प्रोसेस ऑफ आर्टिकल 2 इज गवर्न विथ ऑर्डिनरी लेजिस्लेशन and not with constitutional amendment. So anything under Article 2 and 3 does not come under Article 368, and that is explained in Article 4 of the Constitution. So let's come under Article 4 of the Constitution. If you read Article 4 Clause 2, it would be clear for you. Read the heading of 4 and come to Clause 2, and it says that laws made under Article 2 and 3 to provide for the amendment of first and fourth schedule. No such law shall be deemed to be amendment of the Constitution for the purposes of Article 368. आर्टिकल 2 एंड 3 के अंदर जो भी लॉज बनेंगे, उन लॉज को आर्टिकल 368 के अंदर अमेंडमेंट नहीं माना जाएगा. सो आर्टिकल 2 एंड आर्टिकल 3 के अंदर जो भी लॉ बनते, दे आर मेड थ्रू ऑर्डिनरी लेजिस्लेशन. याद रखेंगे आप, दिस कैन बी आस्क्ड फ्रॉम यू, एंड दे डू नॉट constitute amendment of the constitution under article 368. ये आप याद रखेंगे. So last thing that we need to discuss here is the difference between secession of territory and settlement of boundary dispute. So there is a famous case of Re-Berubber Union case. Wherever there is re appears, it is due to precedential, because it re means precedential reference to the Supreme Court under Article 143 of the Constitution. So in Re-Berubber Union case, the question before the court was that whether secession of territory, territory comes under Parliament's power of internal reorganization under Article 3. क्या सेसेशन ऑफ टेरिटरी वैसे ही होगा जैसे आर्टिकल 3 होती है, और क्या आर्टिकल 3 के अंदर पार्लियामेंट का जो इंटरनल रीएडजस्टमेंट का पावर है, दैट इंक्लूड्स power to cede a territory in favor of a foreign country. So court here clearly said, do remember this very carefully, that court here clearly said the secession of territory do not comes under Article 3 of the Constitution, and secession of territory do not constitute internal readjustment. When we are ceding a territory, basically we are ceding our sovereignty over that part of the territory, and for secession of a territory in favor of a foreign country, we required constitutional amendment under Article 368 of the Constitution. Do remember this, that secession do not come under Article 3, and if you are ceding a territory to the foreign country, basically you are compromising your sovereignty over that part of land, and that's why it requires Article 3 amendment under Article 368 of the Constitution. Simultaneously, when there was a question before the court that settlement of boundary dispute, whether it requires an amendment of the Constitution or not. So court said that settlement of boundary dispute is an ordinary act where two sides are mutually coming to an agreement, and two sides are settling the dispute, and there is basically exchange. There is a give and take of territory, right? Someone is giving certain parts, and at the same time that particular someone is also gaining certain part. So court said that settlement of boundary dispute basically includes exchange of territory, and there is a give and take of territory. So it does not require, do remember, settlement of boundary dispute does not require constitutional amendment, and it can be done through mere executive action. ये आप याद रखेंगे. executive action. So settlement of boundary dispute can be done through executive action, but if there is a unilateral cession of territory in favor of certain foreign country, this required subjugation. This required basically compromising of sovereignty to that part of land in favor of another country. So it requires cessation of territory, required constitutional amendment under Article 368, and the power of parliament to power of parliament of internal readjustment under Article 3 do not covers power of parliament to cede the territory. Do remember this. And anything done in Article 3 and anything done in Article 2 and 3 do not constitute amendment of the constitution under Article 368. They are executed. Every action on Article 2 and 3 is executed through simple ordinary legislation. ये आप याद रखेंगे. So this is all about your union and territory. I hope I have done justice when it comes to explaining the part. If it is too much in English, you can write in the comment section. We'll try to keep it bilingual. See, the subject of polity is very beautiful. You know, polity is a very beautiful subject, but you have to have certain number of revisions. So you have to have a good familiarity with this subject, and once, because this is too much technical and all the sources are available in English only, so eventually one tend to speak in English only because the sources are available in English only. Anyway, we will try to keep it as much bilingual as possible. So tomorrow morning we will have our classes. Lot of classes are scheduled, so keep your spirit high and keep revising. Thank you very much.